Starting with Miss Smith, a mother who says she raised her twin alone and just wants to keep them safe, while the father refused to speak, then walk out mid-hearing. And indeed, you can't force anyone to show up or stand up as a parent. Let's see how the judge handles this.
In this case, the court will note for the record the non-custodial party is Mr. Aaron Young. Custodial party is Candace Smith. Mr. Young made an appearance back in April, so his date of the date that he came before the court was the 14th of April of this year. Ms. Smith was served with citation last year back in June. So both parties are properly before the court this time. As far as the Texas Rules of Civil Procedure, so I'll ask the state for an opening to tell the court what the state's requesting we do here today and what you understand contests and agreements to be at this time.
Thank you, Your Honor. At this time, the state is asking that the court establish paternity based on the acknowledgement of paternity attached to state's file as Exhibits A and B attached to that petition. State is asking for appropriate orders regarding conservatorship, possession, access, and non-disclosure of addresses based on the testimony that state intends to elicit today. State's also asking for support beginning July 1st, 2025, based on the guidelines under the Texas Family Code, as well as medical support and a determination on how the children need to be covered for medical care or health insurance. State is also seeking retroactive support in this case.
All right, so the state appears to be requesting the full gambit here. Is the state requesting this to be a final or temporary order?
State is requesting final orders at this time.
All right, folks, I'm going to go ahead and get you both sworn in. And of course, you have to answer the questions of the state. You have to answer them truthfully and to the best of your recollection and knowledge. At the end of the hearing, I'll allow y'all to make a closing statement or closing argument as far as your case is concerned, because you technically represent yourselves. But what we're looking at here, folks, is the state's requesting everything that the state's entitled to and both parties are entitled to under the Texas Family Code. The state is asking me to set up custody, visitation, child support, all based on what the Family Code does as far as requirements. And in addition to that, the state is requesting back child support or retroactive child support, which under the Texas Family Code, the court has the absolute right to go back to over for the last a minimum of the last 4 years, giving any funds paid to the custodial party by the non-custodial party. But again, the law is the court is to look at the last 4 years and could order that amount, and that amount's to be reduced to a judgment with payments to go along to repay that along with the regular child support, and sometimes that can get a little substantial. So if there's looks like that may be the case in this matter, the court will reserve the right to make this a temporary order to allow the non-custodial party the opportunity to actually seek legal counsel, because again, this could be substantial, and I don't know what it is at this point. But I just did one earlier today where the back child support was $18,000 and some change. So again, it is what it is. But at this time, I'm going to need both of you. Ma'am, muted. Please unmute yourself, and sir, turn the video and unmute yourself, and both please raise your right hand.
You're not gonna want me to unmute myself right now. I'd rather just no.
I beg your pardon?
I'm not allowed to you. I want to be unmuted right now. I'll turn my video off, but I'm not unmuting myself. Please, I'm just want to keep my mouth closed.
All right, here's the deal, sir. You can keep your mouth closed, but if you want to go hear one side, that's the side I've got to go with. So that may not be to your advantage, sir. So, but this is a free country, and you can help yourself or sabotage yourself, whichever you think is best for yourself, sir. But at this time, the court is looking at going ahead and proceeding. And if you don't let me swear you in, sir, then you cannot testify. You understand that?
When I say y'all act like y'all okay when I say, all right, man.
Sir, again, we want to hear what
bro,
you're saying.
Texas, but she didn't, bro. Bro. I don't even care no more, bro. Do what you want. She can have them. I don't care. Bye.
Okay, sir. Whatever. All right, then we're proceeding in default at this time. And ma'am, raise your other hand. Right. Yeah, you're right.
This is my right hand.
Don't worry. I know that by now for sure after 20 years.
Yeah, I'm like, woo.
The camera's got that inverted thing working. But ma'am, do you swear or affirm me testimony you're going to give here today is the truth, the whole truth, and nothing but the truth, so help you?
Yes.
All right, then the court will note for the record, and obviously the record will reflect that the custodial party was present, decided he didn't want to testify, and left the building. So at this time, I'm gonna go ahead and let the state call their witness and proceed. We'll proceed to final at this time. Thank you.
Your Honor, before I begin, I ask the court to take judicial notice of that, those two acknowledgements of paternity, states A and B, and I ask that those be admitted.
All right, ma'am. I'm with the state has your acknowledgement of paternities for your two children in this matter. Is there any objection to court allowing these in evidence at this time?
I'm sorry, I didn't hear that last part.
The state is asking me, the state is requesting I admit your acknowledgement of paternity for your children into evidence at this time. That you and the father signed off on. All right.
Yeah.
All right, states going to be admitted. I'll ask the state to attach a copy of those to the final order of this matter, since that's got to circulate back through me. And I just want to dot my I's and cross my T's on that one. And you may proceed at this time. Thank you.
Thank you, Your Honor. At this time, I call Ms. Smith as my first witness.
All right, Ms. Smith, state your full name for the record.
My name is Candace Tanisha Smith.
All right, thank you very much. You may proceed with your questioning.
Thank you, Your Honor. What are the names of the children before the court today, Ms. Smith?
Their names are Winter and Summer Young Smith.
And what are their dates of birth?
May 3rd, 2023.
And are they twins?
Yes, paternal.
Who do the children live with?
Me, myself.
Did you and Mr. Young live together after the children were born?
Yes, for a short time, up until about March of 2024.
And at
So
March
about
of
2 months.
2024, did you and Mr. Young split for good, or did y'all end up living together again after March of 2024?
We broke up, and he ended up coming back again around September, August of 2024. And then,
Mhm.
I'm sorry.
Oh,
And
and
then he
then
left
after,
again.
when did he leave again?
So he left again December. So after he came back in August or September, he left again in December due to us having an issue around then.
How often does Mr. Young visit with the children?
He hasn't seen the girls since December, like physically. He hasn't seen them at all.
When he did see them during those times that y'all were separated, how long did he normally have the children for?
Oh, each time he left, he didn't contact. So each time of last year that he left, he didn't see the girls or contact us until he was ready to come back.
Has he ever had an overnight visit alone with the children?
Without me being home, no, not by himself.
Do you have any safety concerns about the children visiting with Mr. Young?
Yes, I do.
What are those safety?
We were well, because we were also investigated by CPS. I feel like he is not going to feed the girls, and it's undetermined whether he's going to have an episode on them and like yell at them, because that's what he's known for, yelling at children. Yes, that's my safety concerns, is that he's not going to feed them properly, and he's going to be doing stuff around them that's not okay.
You said there was a CPS investigation, excuse me.
Yes.
Is that still open or is that closed?
It's closed, but they listed all 3 children, because I do have now a 13-year-old boy who's been in the home as well. So they listed all 3 children, and he was found reason to believe, and I was unable to determine, meaning I was fit and he was unfit.
And did you ever have an open CPS court case, or was it just a services case?
It was not an open court case. It was just, we were investigated for 30 days and they provided this document type of thing.
Okay,
And
but
then
you
she
never
also,
had to go in front of a judge?
no, I never had to go in front of a judge for this.
What would you like the court to order with respect to visits between the children and Mr. Young?
All right, ma'am, here's the deal. The norm is if I'm concerned about, problems, then I usually the visit is somewhere between 4 and 8 hours, depending on, I usually restrict those to Saturdays or a Sunday, so either 9 to 5 or 12 noon to 4. That way, you can feed them before they leave, and they'll be back 4 hours. Yeah, but that's the norm. If dad's going to do them by himself. If you're looking at doing them as some type of visitation with you being present, then it is that 4 hours from 12 to 4 And usually, unfortunately, it's your residence, but you know, it's one of the two. It needs to either be with you or by himself. So what are you what's the court to do under those circumstances, ma'am?
I don't really feel comfortable with him around the girls without me being there.
Right
Because my
now?
children are they just turned 2, but they're also not speaking. Like I have them in speech therapy and they're about
Okay.
to be tested
Okay.
for autism. So I don't
All
feel
right.
comfortable because they're on the spectrum. They already look like they're on the spectrum. So I don't feel comfortable without being around them.
All right, here's the deal. Okay, ma'am. Then the norm is under those circumstances, the first, third, and fifth Saturdays of the month from 1 to 5. And like I said, it can be with you or your designated agent to do it, but I need to be very specific because Dad does have his rights, okay?
Mhm.
All right. So if I'm looking at the first, third, and fifth Saturdays of the month from 1 o'clock to 5 o'clock with either you being present or your designated agent, is there a particular spot would work for you, ma'am? And again, outdoors doesn't work. Okay, the weather gets hot, weather gets cold, so I need an indoor location. And so, what are you requesting, ma'am?
Again, my home is fine.
Okay.
And I'll be a person because I don't live that lives close.
Okay.
I can always just call the police and do a civil standby. I've
All
did
right.
it before. So I would definitely do that if I don't feel
All right,
safe
then.
then.
All right, then, man. I'm looking at the first, third, and fifth Saturdays of the month from 1 o'clock to 5 o'clock upon him giving you at least 72 hours advance notice that he wants to see his children for his visitation. Okay. So, in other words, by Wednesday evening, he has to let you know he's going to be there on Saturday. Or do you prefer Sunday?
I prefer Sundays, but I have a question because
Yes,
I also
ma'am.
stated that next year I'll be moving like out of state because I have to take care of my elderly mother who lives like Midwest.
You know, that's
So
the
how would this
I only
I'm
could take
sorry.
a snapshot in time, and for right now, that's the only visitation I would order. If that needs to be modified, then it had to be modified. But for right now, ma'am, he would have to come to you wherever you
Okay.
are, and the court could always order electronic visits also as part of that package. But for right now, and of course, y'all can agree to anything you want. But
Okay.
yeah, based on his behavior here today, that might be a little difficult. So at
Okay.
this time, ma'am, I'm looking at the first, third, and fifth Sundays from 1 o'clock to first, third, and fifth. Every couple of months, there's a fifth Sunday, so it's usually just 2 Sundays a month. But he's got to give you at least 72 hours advance notice that he's going to come to the visit. Do you normally do y'all communicate via text, or how do y'all normally communicate with each other?
I'm always blocklist, but
All right, here's the deal,
he'll
ma'am.
video chat me. I guess he'll video chat. I don't block him, but he blocks
All right.
me. So it is video text or he'll send a random text. Like
Okay, here's
that's
the deal, ma'am. I'm gonna put y'all into a free parroting app. It's free. It's called App Close.
let me write that down.
AppClose. It's the #1 parroting app because it's free. But
Okay.
it requires you to set up an account and then
Uh-huh.
you forward him how to get that account. And I'm going to order that all communication going forward needs to be by AppClose because AppClose has texting function, it has FaceTime function, it has everything. Okay. So if he
Awesome.
doesn't do it, okay, but it's left up. I'm ordering him that if he wants to set up his visitation, it's got to be through AppClose. All right.
Okay.
That way, because if I need to, I can appoint a lawyer to represent the girls, and the lawyer can get a copy of everything from AppClose that you two discuss, everything what happened. So we won't do that he said, she said stuff. All right.
Great.
I prefer to do this on other than your cell phones or on Facebook or whatever. All right. So yeah, we'll just go that route for right now. And I'll go
Okay.
ahead and let the state proceed with questioning. You may proceed at this time now, Ms. Haley. Thank you.
Thank you, Your Honor. And excuse me for a bit of a cough a moment ago, so thank you for your patience there. Has there been any family violence between you and Mr. Young?
Yes.
What
In December.
happened in December?
Okay. A situation happened in December where I was assaulted at the store and then I assaulted him back and I ended up arrested and that's why CPS was called because I told them I do not feel comfortable with him in the home with the children alone.
You
Go ahead. Has either of you ever been convicted of family violence, ma'am, by a court of law?
Nope, I haven't. Nope, they dropped
Oh,
everything for me. Mhm.
all right. Thank you.
I I don't know what's going on with him. Like I said, I haven't really talked to him. So,
Okay. All right. But you
anything
hadn't been called to
besides,
testify or anything like that, right?
no, I haven't because they dropped everything. I have a no bill.
All right. Thank you. All right. You may
Thank you.
proceed, Ms. Haley.
Thank you, Your Honor. You just let the court know that you're okay with visits being at your home. I just want to confirm, do you have any safety concerns regarding having your address in the court order?
He knows where I live. I live in the same place. So as of right now, I'm okay with it because he already knows where I live.
Okay, here's the deal, man. Going forward, if you move, you gotta let him know where you move to if it's in there, because he's got to come visit at your residence. That's
You're
what
right.
you
He'd
do.
have to come.
Yes, ma'am.
I got you now.
Yes.
I'm sorry about the facial expressions. I got you.
That's okay. All right, thank
I'm
you.
okay with it. Yeah.
All right, thank you, ma'am.
Thank you, Judge. How is the child covered for health insurance? Excuse me.
I applied for Medicaid, so the children have Medicaid, the state insurance.
Okay.
Do you have private health insurance available for the kids through any source?
No, ma'am.
Since during the times that you and Mr. Young were separated, did he provide any financial compensation to help support for the children?
One time, $15.
Did he ever purchase any goods or anything for the children?
No, he did not.
In the year of 2024, when y'all were separated, do you know where he worked?
When we were separated, he just told me he was working. The first time he just told me he was in Missouri working for his cousin. That's about it. After that, no, everything's pretty much a secret now.
Do you know how much he earned when he was working with his cousin during that time?
No, that was the first breakup, so no.
Do you know where he's currently working?
Oh no. I just know when he calls and he speaks to girls, I know he has some type of mask or something on, so it looked like it may be construction or something, a warehouse.
Does he have any other minor children other than the two they all have together?
Yes, he does. He has a son, Aiden.
Do you know how old the child is?
I think Aiden is 5 or 6, or he's about to be 6. So the girls are 2. Yeah, so I think he's about to be 6 in September.
Has Mr. Young ever been found to be disabled by the Social Security Administration, as far as you know? Is there anything that would prevent him from working at least a full-time job at minimum wage?
No.
That's the witness, Your Honor. Thank you.
All right, ma'am. Does he have a normal profession he does? Does he work construction? Does he work building houses? Mechanic? Does he do anything while y'all were together? Did he do anything like that?
That was the issue. He kept getting fast food jobs when he is a brick mason, but the most jobs he would have is like moving jobs to help people move furniture or like Ashley's or things like that. And then he would work it, and then it's like either the work ethics wasn't there and he would be let go, or that was the issue. It was basically constant jobs going back and forth.
Okay.
Yeah.
All right, got it then. All right then, ma'am. Is there? Well, I'm getting ready to go ahead and now let's the state in the closing to tell the court exactly what the state's asking for as far as child support, cash medical support, retroactive child support. I'm already and I'll make the decision on what type of conservatorship to order. And obviously I'm going to do the visitation package as I already stated. So at this time, I'll let the state go ahead and make that statement. And then at the end of after I make my rulings, ma'am, you'll have the opportunity to tell the court if there's anything else you want me to try to do here today. Thank you.
Thank you, Your Honor. If I can have just one moment to get a good retroactive support calculation, it shouldn't take me very long.
Not a problem. I'll pause the recording. Thank you.
Thank you, Judge.
This one's Mr. Hernandez and Miss Olivia fighting over child support and who stepped up. But when two sides are struggling, who should the court believe? Let's see how this plays out.
All right.
Hello?
Mr. Hernandez, can you hear me, sir?
Yes, ma'am.
And Ms. Olvera, can you hear me?
Yes, ma'am.
All right. Okay, then let's see. I'm going to call for hearing Hale County cause number, let's see, A39022130, styled in the interest of Nitha Ray Hernandez. We're here today on the Attorney General suit for modification of support order and motion to confirm support arrearage originally filed on November 21st of 2024 and docketed before the 64th District Court of Hale County, Texas, being heard today by order of referral by the Associate Judge for Child Support Matters. Is the Attorney General's office ready, Mr. Benishek?
Ready, Your Honor.
All right. And Ray Hernandez Jr., are you ready to proceed, sir?
Yes, ma'am.
All right. And Sasha Oliveira, are you ready to proceed?
Yes, ma'am.
Okay. All right. And is the Attorney General's office ready?
Yes, Your Honor, we're ready.
Okay, you may proceed.
Thank you, Your Honor. I call Sasha Olvera.
Ms. Olvera, if you would please raise your right hand. Do you swear or affirm that the testimony you'll give in the cause before the court today will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you, ma'am. Mr. Benishek.
All right, Ms. Olvera, are you the mother of Nisa, the child who is the subject of this suit?
Yes, sir.
And who is Nisa's father?
Ray Hernandez Jr.
Is that the same Ray Hernandez Jr. you see on your screen right there?
Yes, sir.
Okay. And was Mr. Hernandez previously ordered to pay child support and medical support for Nisa?
Yes, sir.
Has he always paid in full and on time?
No, sir.
Has he made any payments to you, in fact,
No, sir.
through the child support system at least?
No.
And Your Honor, I'll offer in evidence the Attorney General's pay record. It's an updated version of the copy that was presented at the temporary orders hearing. And I'll offer that as State's Exhibit number 1.
Okay, it's not an updated, the one that's in the court folder is not an updated copy of the one that was offered at the temporary hearing. I don't think one was offered at the temporary hearing because it was an agreement that was announced. Secondly, this is a brand new pay record that starts as of the judgment date of the temporary order. So that's not what it is.
All right, I apologize, Your Honor. I thought we had presented one at the last hearing. In any case, I would offer the Attorney General's pay record as State's Exhibit 1.
Okay, is there any objection to the pay record coming into evidence? Mr. Hernandez?
What's the pay record?
The pay record is an accounting of what has accrued and what has been paid, or in this case, not been paid since the last hearing, which was you were here for, was on March 13th of 2025. It's just their accounting of what amounts accrued, and really it was, I guess, at the time, child support continued for March, since we were March 13th. So it shows them, but a judgment was done as of February 28th for child support and medical support. And then there was an accrual for current support and current cash medical support for March on March 1st. And then beyond that, it's just interest accruals on those, on the judgment amount that were done back on those dates.
I've been incarcerated, so how could I pay the amounts? I don't.
Sir, well, I'm not arguing about whether you could have paid or whether this is correct. It's the question is, do you have an objection to it being admitted into evidence?
Well, I don't have objection of it because I'm still
Okay,
going to do
Ms.
it. So it doesn't
Olvera,
matter
do you have an objection?
No, ma'am.
All right, it will be admitted as State's Exhibit 1.
Ms. Olvera, what kind of health insurance does Nisa have right now?
She has Medicaid.
Okay. And I'll pass the witness, Judge.
All right, Mr. Hernandez, do you have any questions for Mr. Olvera? This is Ms. Olvera. This is not a time for you to testify. You'll get a chance to do that in just a moment. Right now, I'm asking you, do you have any questions for her?
No, because it's going to lead to arguments. So I don't want to talk to her. Like, it's
Okay.
not no sense to
All
talk
right.
to her.
No questions? Ms. Olvera, do you have anything you want to add to or explain about your testimony?
No, ma'am.
All right, Mr. Benishek, call your next witness.
I call Ray Hernandez.
Mr. Hernandez, please raise your right hand. Do you swear or affirm that the testimony you give in the cause before the court will be the truth, the whole truth, and but the truth?
Yes.
Okay. Mr. Benishek?
All right, Mr. Hernandez, you are the father of Nisa, is that correct?
Yes, sir.
Do you have any other children below the age of 18?
Yes, sir.
And how many do you have?
I have 3 other children.
Okay, 3 other children. What are the ages of those children?
Brianna Nicole Gosh, she's 17. Jacoby Hernandez, he's 2 years old. And Soraya Hernandez, she's 1 year old.
And are there child support orders for all of those kids, ordering you to pay child support for them?
For Brianna, yes.
Okay. And the other 2, do they live with you?
They live with me, yes.
Okay. All right, and so you're supporting them because they're living with you, is that correct?
Yes, the same way I was supporting Nisa when we were living together too.
Okay. What kind of work do you do for a living?
Right now, I've been doing little side jobs like landscaping, but The guy that I've been working for, he's no longer. He was an elder gentleman. Like I've only helped him like twice since I've been out. So, and right now I have to have a 9 to 5 because I'm have to go look for a legitimate job. I can no longer do my side jobs.
So you're still looking for something steady. You're not employed right now. Is that right?
Yes, sir.
Okay. And you alluded to getting out. You were in prison before. Is that correct?
Yes, sir.
And when did you get released from prison?
April the 17th.
Okay. And so between then and now, you've been doing just odd jobs?
I've like I said, worked twice with this gentleman. Like so, it hasn't been working with him every day. I've only worked with him twice, and that
Okay.
the amount he paid me was only like $50, and that went to my parole. $40 went to my parole, and then Pampers for my children here.
Do you have any special skills or any kind of work you'd be looking for, like construction or commercial truck driver or anything like that?
Right now I'm just trying to do what I can, like landscaping and remodeling. But
Okay.
right now they don't have where I'm at. They're not really, you could say, felony friendly because yeah, they discriminate a lot here in this town. So it's
Okay.
kind of hard to find a job here. Like they have a lot of positions open here, and I apply to jobs that have openings, and I have proof y'all want to see it, and they've denied me opportunities because I have tattoos, visible tattoos, or my me having a felony, me having felonies.
So the felony makes it difficult, but you don't have any other like disabilities that would keep you from working at least a minimum wage job. You were able to find one.
Yes,
Okay.
sir. If I can find me a minimum wage job, I'll actually do it.
Okay. All right. I'll pass the witness, Judge.
Ms. Olvera, do you have any questions for Mr. Hernandez?
No, ma'am.
Okay. Mr. Hernandez, where is it that you are located, sir?
In Guyman, Oklahoma?
Okay. And you've been to job search places? Is there a workforce
Yes.
commission or something like that
Yes,
there?
ma'am. Yes, I went to the unemployment office when I first got out. They applied me to the seaboard. Here it's a meat plant, and the same situations happen. Like I was hired there when I first got here, and I'm not re-eligible for rehire there. I had to keep trying every 30 days. I applied almost every job here that has openings available. And like I stated to the Attorney General's office, like they're not very felony friendly here. Like they're very judgmental here. Like Brahms was hiring. I've seen a couple people with visible tattoos. I'm guessing because I barely got out of prison, I'm felon, and I got neck tattoos and arm tattoos, like that they won't hire me. But I don't know. Really sit here and I could just tell you what I feel and predict that's the reasons, but I've been told from Brahms that they won't hire me because I have visible tattoos, but there's been people there that have visible tattoos. The local McDonald's here, I've been up there. I've been in a lot of places here, man. Like, and if y'all don't, I have records to show it. Like, if y'all wanted me to send it to y'all, it's very hard to get a job here. They're
Yes, sir.
very judgmental here.
All right. All right, but the parole, are they assisting you or just telling you where to go to look for a job?
They don't at all, man. Like they don't. I've been up to the courthouse. Matter of fact, I had a court hearing on the 11th before our original court date on the 12th. I asked the judge there, why don't they have the needs that the probation office or the parole office needs that they need to have, like, because when I was in DOC, they had a class called life skills, and I was commandeered by one of the main parole officers from Oklahoma City, and they were saying that they had to have the parole board and all that had to have stuff to be able to help you find jobs and find felony friendly jobs that will hire you as a felon. And when I presented that to here, they were like, no, they don't have nothing like that. This town they don't believe like to assist anybody, and they don't have the financial assistance to help you out with stuff like that. And I was like, okay, so what do I do about it? And they were like, well, we don't know what to do.
Okay. Is there are you able to move somewhere else?
If push comes to shove, yes, ma'am, I am considering to move either back to Texas or to another state, another here in Oklahoma, because this is one of the worst ones to live being on parole. And they stated that back in DOC, like this county and another worstest place to live in, due to that these counties don't want to help you, but they're quick to incarcerate you, or if you owe over $40. Like they were threatening me last month that they were gonna lock me up, and I still hadn't found a job. Like I had already gotten out in April, and they already were charging me in May, and it didn't make no sense. Like they already were charging me a week later, and already sent me a letter in saying that if I don't pay this amount within this time, that I was gonna get incarcerated. I was like, well, y'all knew I barely got out. Like they don't. I'm not one of these local farmer boys or local town guys that lived here all their life and able to find a job real quick, like, or know somebody that has a job or farming or any kind of jobs here. So like, man, I don't know. I'm just very hard to live here, like to find a job.
All right, Mr. Bunishek, more questions?
No, Your Honor, we rest.
All right, Ms. Olvera, Mr. Bunishek's rested. That means he doesn't have any more witnesses or evidence. Do you have any witnesses or evidence you want to present, ma'am?
No.
Okay. Do you want to testify additionally?
What do you mean?
Do you have any more testimony to offer?
For an example, he can work at a golf course. I can say that for sure, because a golf course doesn't judge people on tattoos and stuff like that. I know that because I've seen people with stuff like that.
Okay. All right, Mr. Hernandez, do you have any additional testimony you want to offer, or any witnesses or evidence you want to present?
Yes, ma'am. I do want to and like present to the court today. Why am I paying back child support if me and Miss Oliveira were together at the time? And then at the time of the hearing, when we made the agreement, it was just for the TANF to pay back on the TANF situation. And then later on, they tagged on the child support, and they said that I agreed to that. It was just
No, that's not how it works, Mr. Hernandez. That's the Attorney General's office.
Well, that's what was told, Miss Honor. Your Honor, can I finish?
I don't know, sir. That's
Well,
not what happened. I've got the orders before me.
Can I finish? Like finish, because it was an agreement. Like, and like
Okay.
I haven't cut. That was the agreement, ma'am. Like I know what I signed there that day, so you can sit there and like go against me and say no, no, ma'am, that's why I signed, and that was the agreement. And then later on, there was child support papers getting sent in saying that I owed child support, and it was just agreed to pay back the TANF because me and Miss Oliveira were living together. So I don't see why I paid them. Like I was there to support her, and then I still owe child support. Like that doesn't make no sense to me.
Can I say something, Your Honor?
No, ma'am.
Okay, then.
We're not going to argue about this. I have the orders in front of me. They don't say anything about paying TANF back. They're signed by both of you and sworn that this is your signature and your agreement. And so that's not what happened.
That's what was told to me, ma'am. That me was sitting in the office in Lubbock, Texas. That's what we said there.
Sir, can you read, sir?
Yes, ma'am. Yes, ma'am.
Okay,
I understand. And so don't try to make me stupid. Like I know what I was told to me in front of me at the Attorney General's office in Lubbock, Texas,
Okay,
ma'am.
well, you didn't read
Like,
the
that's
order
the
that you
only
signed
thing
in. All right.
Well,
this
then,
all right. This hearing is concluded. I'm going to enter a judgment against Mr. Hernandez in the total amount of $38,363.15 for child support arrears and $10,088.35 in medical support arrears. As of May 31st of 2025, I will order Mr. Hernandez to pay $200 a month toward the child support arrears and $20 a month for the medical support arrears. As for current child support, and I will begin those payments on July the 1st. As for current child support, I do understand that it's difficult to find a job when you have been incarcerated and do have felony convictions. I'm going to give Mr. Hernandez one more month forward to get employed. But Mr. Hernandez, I don't know. I understand you're in a difficult situation, but people do get jobs out of prison. And it may mean having to move somewhere else to find a job. I don't know. But I will set child support at the minimum wage presumption amount for one child when there are three others, which is going to be $163 per month. I'll set medical support at $25 a month, and all of those payments will on August the 1st of 2025. I will tax all court costs for today's hearing against Mr. Hernandez as billed by the District Clerk of Lubbock County to be paid within 1 year of today's date. I think that covers everything, Mr. Benishek. Have I left anything out?
I believe that's all, Your Honor.
All right. Every party to a hearing before the associate judge is entitled to a new or de novo hearing in front of the referring court. The new or de novo hearing must be requested in writing. The request must be filed within 3 days of the notice of the substance of my ruling and served on the other parties to this action. It must specify what issues will be heard by the referring court. The referring court will set a hearing within 30 days, but the requesting party must obtain a setting from the court. One party asks for a de novo, any other party may ask for one within 3 days of the initial request. Nobody asks for a de novo, my order becomes.
Getting out of prison is hard, but as parenting pause after that, well, here is Miss Gomez, a mother, trying to rebuild trust after years of limited visits. But the father isn't convinced their son is safe with her. He says she's unpredictable and claims she once hit him in front of their son. Crazy, right? Let's see how the judge handles this.
Court of Butler County, Kansas. The parental parties to this case are Christina J. Gomez and Jason T. Christensen. It's Butler County case number 2020 DM 115, beginning with petitioner. Would counsel announce appearances for the record, please?
Christina Gomez appears via Zoom with her attorney Terry Bell, who appeared via Zoom in a different location.
May it please the court, the respondent Jason Christensen appears by and through counsel Taryn Folson, both appearing by Zoom from separate locations.
Very well. The matter comes before the court at this time for hearing on a motion by the petitioner to modify visitation rights in the case. It does appear that that motion at least was initially opposed. Counsel, have there been any agreements reached regarding the issues raised by the motion?
No, Your Honor.
All right. The court has received exhibit packets from both parties in the case. Mr. Bell, this is a hearing that was set that involves limited time. I do want to kind of get right to the point here. I think you're alleging that things have changed with Christina's situation over the past several years, which should give this court occasion to modify the current parenting plan. Fair statement?
Yes.
All right. Where is your client currently residing?
She now moved to McPherson so that she can be closer. So she does have a residence. And
what is this residence exactly?
Miss Gomez, what's your residence so you can tell everybody?
I have an apartment here in McPherson.
Is this a part of some sort of facility that you have this apartment?
No, I have an apartment. It's difficult to find housing in the McPherson area, but I've been here since October and I plan on staying for another year.
And I trust Mr. Christensen is aware of your address?
Yes, he's been inside here.
All right. Who lives there with you?
I live here by myself. My daughter stays with me on
How old is your
occasion.
daughter?
She's 17.
Okay. What type of sleeping arrangements do you have for the child involved in this case?
He will have his own room
Why do you live in McPherson, Kansas, of all places?
to be near my son
All right. And where does your son, where is the father's current residence?
in McPherson.
Okay. So you're both within the city of McPherson, Kansas?
Yes.
Okay.
I had been commuting for work to the Newton area and had been working in Newton for a year. And I now commute to Hutch 20 minutes for work. I work 12-hour shifts, but I've been here since October and I plan on staying.
What kind of work do you do?
I'm a registered nurse.
Okay. Aren't you assigned to work weekends?
Every other weekend. So we
I
have a
see.
rotating shift. This is my weekend work. I work Friday, Saturday, Sunday. I have Monday, Tuesday off. I work Wednesday, Thursday, and then I have a 3-day weekend, Friday, Saturday, and Sunday.
So you contemplate the parenting time that you're suggesting be on your non-work weekends, all right? Do you have your own transportation?
Yes,
Your own car that is accessible to you?
yes.
Okay, all right. That is a basic factual summary. Ms. Folston, do you dispute any of the facts that have been stated by the petitioning party in this case?
Your Honor, I believe my client had previously told me that her apartment is a studio apartment. So we question whether or not there is in fact a separate sleeping accommodations for the minor child. But other than that, we don't dispute the rest of the factual statements.
It's a 1 bedroom, but I have a day bed in the living room, and that's where my daughter stays. So when Lucian is here for a weekend, he can have that room, and I will sleep on the day bed.
Where does your daughter sleep then?
She won't. We have a couch here, but my daughter won't be here. Well, I can't say that because I have Friday, Saturday, and Sunday. She's 17, so she's very busy, but she will be here on occasion.
Then to answer the question, then where does she sleep?
We have an air mattress, we have a couch, but she doesn't stay here full time. She's 17 years old. But I have a room for Lucian. And I have a day bed here, and my daughter can stay on the day bed. I can stay on the couch. I have an air mattress if she does decide to stay over.
All right, Ms. Wilson, I'm going to address you. This court made some modifying orders, I think, back in late 2020. Obviously, the child was very small back then.
Yes.
And the court's order was specifically couched as a temporary parenting plan, which that temporary plan has now been in effect for over 4 years. Christina Gomez has been apparently under Mr. Christensen's decision-making, having very limited parenting rights. Is there any reason why an every other weekend schedule shouldn't be adopted at this point?
Your Honor, my client still has concerns about the safety of the minor child while in the petitioner's care. Your Honor, he has been encouraging visitation between the minor child and the petitioner because he believes it is important for the mother-child relationship. In fact, there are multiple times, as shown by the calendars that we provide in our exhibits, that the petitioner gave no notice and would just show up at his house when she wanted to exercise parenting time. My client would allow it. Your Honor, we did submit some exhibits, including text messages about the petitioner wanting to have the minor child tested for STDs because he had a rash on his arms that he was seen by a doctor for, and it's molluscum. It's a viral infection that is common, and it is non-painful. He was treated for that. I did see in the petitioner's exhibits that pictures of that rash were submitted. Your Honor, one of the text messages that was submitted by my client includes a message from the petitioner that states that she wants to send the minor child to a gas chamber and twin sister to the crematorium. To my knowledge, there is no twin sister. So I'm not sure if she was under the influence at that time or why she would make those statements, but that is very concerning.
How long ago did she make those statements?
Your Honor, I believe that was in 2021. It was quite a while ago.
I really want to focus on 2025, Ms. Folston.
Understand, Your Honor.
Some historical context is always important, but let's talk about now.
Yes, Your Honor. So it appears that she has found a stable residence for the first time in several years. My client is a little concerned by her statement that she's going to move in a year. We don't know if that means she's going to move within McPherson or when. But Your Honor, at the end of the day, my client is just concerned that if she gets this visitation, she may try to abscond with the minor child, that she may not give the minor child back to him. So he still has these concerns. And the fact that she now has a residence doesn't necessarily resolve those concerns. And frankly, the concerns that the courts had in 2020. I know the court is very familiar with this case and all the issues that the petitioner had when the court did end up awarding my client primary residential custody, granted on a temporary basis. But that has been in place for many years. And other than getting a residence, the petitioner has failed to show material change in circumstances or how her proposed parenting plan is in the best interest of the minor child. I think going from having supervised visitation for 1 hour a week to unsupervised visitation for overnights and several days at a time may be too big of a leap. And if the court is considering going to unsupervised visitation, perhaps we have some sort of phase into that so the minor child can adjust to the new plan.
All right, Mr. Bell, I'd like to address you at this point. I'm sure you have some things that you'd like to add to the discussion.
Thank you, Your Honor. I think things have dramatically changed from when the court heard the original hearing. At that time, she was living in a safe house. Now she's stable. She's consistently worked as a nurse. I don't think there's any issues with absconding with a minor child. She's employed, and that's never been an issue anywhere that she was going to abscond with a minor child. Even at the original hearing, there was no issue of absconding with a minor child, just she didn't show up for any of the hearings. So I think she has demonstrated that she's going to stay in McPherson. Whether or not she decides to stay another year, we'll have to address the issue at a later time. But at this time, she has a current residence or current employment, and the minor child knows her as mom and has had visitation with her for over 4 years. There's nothing that suggests that this minor child couldn't have alternating weekends with my client. There's nothing that would suggest absconding. There's nothing that would suggest that she's going to harm this child. Nothing along those lines. So I think it's a reasonable request and in the child's best interest. I note in the original order that the court was concerned to make sure that the father would have visitation, establish a good relationship with the minor child. In this case, that's what we're trying to do. And this would prevent father from getting phone calls about visitation, because the visitation schedule that was originally set up was never set up as a specific date and time. So it makes it very difficult on all parties when you don't have a date and time to schedule a visitation for the minor child. That creates uncertainty for this minor child because my client might be available and then he might not be available. So how do you schedule it? This is a consistent schedule, stability for the child. There's no reason. I think it's a reasonable request and in the best interest of the minor child.
Recite into the record, Mr. Bell, as to what the structured parenting plan would be that you propose to this court.
Thank you, Your Honor. We'd have alternating weekends. Let me get to the exact parenting plan. She would have alternating weekends from Friday at 5 until Sunday at 5 and any other time that they agreed to. I also included a holiday parenting schedule because there isn't one at this time. That Easter, mom would get even, dad would be odd. Mother's Day would always be with her. Father's Day would always be with him. The parents' birthdays, whichever one it was, child would be dad's, mom's, child would be mom. Child's birthday, we'd alternate with mom getting even years, dad getting odd years. Memorial Day weekend would be even and odd, even for mom. Labor Day weekends, even for mom, odd for dad. Halloween, odd for mom, even for dad. Thanksgiving, half and half. The parties would have to communicate as to how that would work. Same for Christmas, New Year's, and spring break. And the 4th of July would be odd for mom and even for dad. I also included the provision that law enforcement shall assist in enforcing the parenting time, which would alleviate any issues that the respondent have in not returning the minor child. But I think the parties can somewhat work together. Obviously, they have worked together in the past to arrange visitation. So I think that this schedule would be in the best interest of the minor child.
All right, Ms. Folston.
Thank you, Your Honor. Again, Your Honor, I believe that we need to essentially phase into this more extended parenting time between the child and mother. Your Honor, my client does still have these concerns. There was a time period in which the mother hit my client. I believe that was in 2024 in front of the minor child. There are ongoing concerns. I would note that in the hearing order from December 2020, it does specifically state that the court believes that otherwise the petitioner mother will abscond with the party's minor child and the respondent will not be able to have access to the minor child. One issue was that the mother went to a shelter and then police could not serve her. Police could not get the minor child. So even with the law enforcement provision, if mom goes to a shelter, that can become problematic again. Thank you, Your Honor.
Is there any reason to believe now in 2025 that Ms. Gomez is going to have a need to go to a shelter?
Your Honor, I would hope that there's no need to go to a shelter, but my understanding is that there may not have been a need in the first place. Of course, I was not the attorney of record at that time. I'm looking at the court documents. To my knowledge, there should not be a reason, but my client does have concerns that she may still try to go.
His concerns are based on what? Because it happened before, so it may happen again. Is that all he has?
That's correct, Your Honor.
All right. Court doesn't always conduct business this way. The attorneys have done a good job arguing on behalf of their clients, but I did give Christina an opportunity to address the court personally. So I'm going to turn to Mr. Christensen. You've been represented well. I think I understand your arguments and your concerns, but is there anything that you personally would like to add to the discussion here?
The communication between Christina and I is unique. I stand back and I let things happen because I'm walking on eggshells on her visits. All right. Because I don't know what her mental decision is going to be. In fact, I like her to call me before she comes over so I get some kind of idea of her mental, her situation, her whatever's going on with her on that particular day. I am very proud of Christina for getting her own place. She has kept a job as a nurse for a long time, but I think she bounces around to different nursing jobs, so to speak. There's very seldom much help. She's not co-parenting, she counterparents. And I think this whole ordeal is about control more than anything else. And
well, Mr. Christensen, that's interesting that you say that because haven't you had control for over 4 years now?
I have.
Haven't you been the one that's been telling her when she can see her son and when she can't?
I don't really tell her. I let her, because her schedule is so nights, days, weekends. I just kind of sit back and let it work. You know what I mean? I don't tell her when she can. I try to work with her as much as I can. In fact, there was a time when I used to go to Salina when she lived in Salina, and I would pick her up to come visit the boy for a Saturday, and that got too much for her because she decided to argue and be very mean, so to speak. And that's been a couple years ago, and I'm concerned about how things would go after. I'm sure a couple visits would go good, and then there would be a time where it ain't going to work out good. I'm trying not to say anything that I don't know because I like to tell the truth. At the end of the day, I'm concerned for Lucian, period.
After hearing from Mr. Christensen, Mr. Bell, anything further that you would like to present to the court?
No, I think the court has a good understanding of what's going on.
Ms. Folston?
No, Your Honor, thank you.
All right. The court recalls that there was a time in this case where Ms. Gomez, I think very irrationally, tried to keep Mr. Christensen from his son. I don't like that kind of thing. I didn't like it then. I don't like it now. Ms. Gomez, I would hope that there would never be an occasion where you would keep this boy away from his father.
No.
It is legitimate for the father to have concerns. Every parent that's separated has concerns about the other environment. They should have concerns about the other environment. They would want their child's welfare to be first and foremost in their mind, and anything that might be contrary to that, they should be concerned about. But Ms. Gomez, Mr. Christensen has had primary residential custody for a period of time. You've apparently improved the stability of your own living situation by having your own place and apparently a quite responsible job that you have. It's time to see, in this court's view, if you are up to what you're asking for. Can you handle this boy for a 2-day period?
Yes.
Well, I understand you're telling me that, but the question is really kind of rhetorical. Can you do it or not? Can you show us that he is just as well off at your place for 2 days as he is at Mr. Christensen's the rest of the time?
Yes. Yeah.
Well,
he will know what to expect. I know what to expect, and he's not disappointed, and I'm not disappointed.
can
And
you also communicate appropriately with the father about any concerns that you might have or might arise during your parenting time?
yes.
And how do you two communicate with one another?
So we have a cell phone, and for a while I had a separate phone for Jason. I have a T-Mobile that I use for family and friends, and I now have a Cox phone for work.
All right. So I really, my question wasn't phrased very well. Can you talk to him on the phone?
Yes. And
Telephone
Lucian will always
conversations.
have access to my phone to get a hold of his father if he wants to talk to his father.
The court finds that the proposed parenting plan is not unreasonable. It does appear to be currently consistent with the best interest of the child to have an expanded access period with his mother. He needs to have both his mother and his father involved in his life, but he needs to have two cooperative, stable parents on each side of this case. And it'll be up to Mr. Christensen and Ms. Gomez to make sure that he always sees that you two are at least working together for his welfare. I think there should be some consistency here. Mr. Christensen, I'm sure, has established a routine for this boy. He's what, 5 now?
Yes, sir.
All right. So he probably has established routines regarding when he eats his meals, when he goes to bed, and things like that. And I would think that whatever he's used to at father's house should be strongly considered to also be the plan at mother's house.
Yes.
He shouldn't have things dramatically different as far as schedule or otherwise, discipline or anything else at your house as compared to his dad's. But the court's going to implement the schedule as suggested regarding weekends. However, at this time, the court is hesitant to add a detailed holiday schedule. I think first we need to attempt a weekend schedule before we broaden holiday weekends, split up holidays, and everything else. Mr. Christensen, I would just simply ask you that if Christina wants holiday visitation time, that you try to work it out with her.
Absolutely.
There's no reason that Lucian should be denied having Christmas with each parent. Thanksgiving can also be divided with you living in the same town very workably. The Mother's and Father's Day thing, I don't know how that's going to fall regarding Christina's weekend, but perhaps some additional visitation might be appropriate on Mother's Day or on the child's birthday. And I think that there needs to be some spirit of cooperation. But with that said, some structure in place, and the every other weekend is the structure which the court is going to specifically order. So, Christina, when would this start? What is the weekend that you have off next?
So I am scheduled to work this weekend. It would be the following weekend.
All right. And that's okay. Let's identify that date.
Looks like the 27th and 28th, sir.
That would be correct.
All right. We'll begin the mother's parenting time periods on the every other weekend basis, June 27 and 28 of the year 2025. Every other weekend thereafter until further order of the court. Nothing about this order precludes other parenting time that the parties may agree upon. And again, the court is encouraging specific sharing of time on holidays. Mr. Bell, I'm going to task you with drafting an appropriate journal entry modifying parenting time.
Thank you, Your Honor.
Consistent with the court's orders made here today. I do want to admonish Christina about one thing. If you have a structured schedule that the court has ordered where there's supposed to be an every other weekend routine, you have to make sure that those weekend visits take place. You can't blow them off or make Lucian think that he's not a priority to you. And I do understand there may be some extraordinary work circumstances that come up, but it's very important that once we set this routine, that you stick to it.
Yes. I would like to have him more than, that every other weekend throughout the week. But as of right now, with me working 12-hour shifts, to propose that I have the same rotating schedule, but every other weekend. So
Well, that's a very responsible position to take. And I understand that you'd want more time than the weekend structure, but that is a responsible way to look at things. Further, Mr. Bell, if you'll include in the order that this parenting plan, which the court has ordered today, is specifically dependent on the mother retaining a suitable residence within McPherson, Kansas. The close proximity of the parties at this point is a factor in the court's decision. Dad's not very far away, and the child's obviously very familiar with McPherson. So if she moves away, especially any considerable distance, this court very well may take a different look at this parenting order.
We'll include that.
So you can move, Christina, but it has to be within McPherson.
So I would have been in McPherson sooner, but it was very difficult to find housing inside this area. It's a small community. I do have a good rapport with the landlord and my neighbors.
Well, good.
So
I'm just saying that if you move, it has to be in town.
Okay.
All right. All right. Mr. Bell, do you need any further clarification regarding the court's orders at this time?
No, Your Honor.
Ms. Falston, is there anything further from your perspective that the court currently needs to address?
No, Your Honor. Thank you.
All right. All right. Good luck to the parents in this case. Ultimately, what we're all just interested in is this boy growing up as just normally as he possibly can, with proper involvement and structure with both parents. So good luck in that regard in co-parenting in his best interests.
Thank you.
If there's nothing further at this time, then this matter is currently in recess and the meeting may be ended for all at this time.
Thank you.
Sometimes, the hardest part of co-parenting is learning to believe the other person can change.